So, good afternoon, everyone. We're here to discuss the Secure Act 2.0 in a very conversational format, providing you with general understanding of what our legislators were, what they meant to do in passing the act and what the practical outcome has and will be for your nonprofit organizations and your employee. I am your host, Carmela Elko, Managing Director at Trinity Advisors Group, and I'm joined by my esteemed panelists, Michael McCabe, President at Trinity Advisors Group, and David Hall, Chief Marketing Officer at Hall Benefits Law Group. So welcome. Just to give you some perspective, there are 92 provisions in the Secure 2.0 Act. So if you found it challenging to keep track of what applies to your plan and when, you're not alone. So for this particular webinar, we've pulled some very specific provisions that apply to primarily 403B plans. We've held other sessions that have more, additional deep dive into some of the other provisions, but we're here to give you a general understanding of a few meaningful provisions of the most impactful, that will have the most impact to you and your employees. So we also conducted, like I said, another series, and we're happy to send you a replay of that. We will be recording this particular WebEx as well, so that you may refer back to it or share it with your colleagues. In addition, you may download some of the materials we have in the handouts section of the control panel, and please feel free to ask questions. Again, there's a questions bar in the control panel, so we will answer those if we have time, time permitting. So without further ado, let's begin. So first question, Michael and David, can you briefly discuss the idea of intent versus impact for the audience and explain why we took this direction in our conversation?
Sure, Carmela, I can take that question, and thank you for your introduction. By way of background, my name is David Hall. I'm the Chief Marketing Officer here at HBL. We're a boutique ERISA law firm headquartered in Atlanta, but we do serve clients, including nonprofits, in 39 states. And so, back to the question, why are we talking about intent versus impact? Well, the fact is you can Google Secure 2.0, and we don't want you to do that because we want to actually talk about thinking critically about how to implement certain things that might benefit your plan. We want you to be thinking critically not about all the ins and outs and the granular aspects of operation of these 92 different provisions, right? But instead about what is appropriate for you to be thinking about as a nonprofit plan sponsor of a retirement plan. So if you want a provision by provision breakdown of the act, you can get that just about anywhere. At the end of the day, what really matters is how this impacts plan sponsors. And so that's what we're going to lean into today. So when we think about how Secure 2.0 impacts plan sponsors, let's start by thinking about what was the intent of Congress in passing this legislation. This legislation was passed, signed into law on December 29th, 2022. It has four stated intents. First, to expand employee access to retirement plans. Second, to increase Americans' retirement savings. Preserve Americans' income, number 3. And then number 4, which might be most interesting to those of us here, at least from the perspective of a plan sponsor or running a plan, streamlining formerly complicated retirement plan rules for both you and your participants. So now that we've looked at those 4 stated intents or intentions of the act itself, as stated by Congress, Michael, maybe you could jump into the areas of impact we'll be speaking to specifically today, and then there will be some examples that we can all jump into together afterward.
Absolutely, and thank you, David and Carmela. So before I jump into that, let me introduce our firm, Trinity Advisors Group. We are a 401k and a 403b consulting firm. And what that means is we help plan sponsors and their committees meet their fiduciary obligation. We also help drive education, not only at the plan level, but sometimes more importantly at the participant level. So With that being said, David, you mentioned the intent. So let's talk a little bit about the impact. So we don't know what it is yet or what it's really going to be, but we do know that it's going to be really significant. And the reason I say that is just like all government regulations, this is not easy, simple, or clear. If you feel confused, you're not alone for sure. I think it's going to feel like drinking water from a fire hose as we move forward through these different provisions.
Thanks, Michael. And today we're going to be talking about different provisions that are going to cover investments, employee withdrawals, and plan design. So, Michael, can you break down those areas of impact that we'll be diving into a little more detail today?
Absolutely. So, we're going to talk about 3 or 4 provisions, time permitting, that are not only going to impact plan sponsors, but also their participants. So first, one of the really exciting pieces is the Act has now opened the door to allow collective investment trusts, also known as CITs, in 403B plans. Secondly, there's a change in the hardship withdrawal provisions and how that impacts participants. Third, we're going to talk about long-term part-time employees and how they impact or how they will impact the plan itself. And with time permitting, we'll talk about multiple employer plans that are now allowed to be used with 403B plans.
Okay, well, Michael, let's start with collective investment trusts, or as you said, we call them CITs. So first, can you briefly review what a CIT is and why it's important to plan sponsors? And then next, David, please update us on where things stand under Section 128 of the Act with allowing them in 403B plans.
So first, the definition of a collective investment trust. A CIT is a pooled or commingled investment fund available only to qualified plans. And up until Secure Act 2.0, it was only available inside 401k plans. So there's a couple advantages. Well, there's several, but there's 1 or 2 that we really need to focus in on. And the first one is there's a potential for lower costs, investment costs to participants through the fund's ability to lower overall compliance, marking, and administration features or costs. So that's really good because what that will do is it will drive down investment-related costs to participants. One of the disadvantages of collective investment trusts is while they mirror their mutual fund partner, there's not a lot of them available right now. So there's a limited investment strategy available, but that is continuing to expand. The other challenge is, unlike a mutual fund that has a 5 alpha code tracking symbol, collectives don't yet. So there's a little bit harder process to go through in order to be able to track all of the information that you would like to, like a mutual fund. So currently, under the current law, 403B plans are generally limited to annuity contracts or publicly traded mutual funds, right? This limitation cuts off 403B plan participants, generally employees of charities, public schools, college, universities, nonprofits, from access to collective trusts, which I mentioned are used in 401k plans. Well, effective 2023, this year, Section 128 would permit 403B accounts to participate in these group trusts like other savings plans, qualified savings plans like 401ks. But there's a catch. So David, do you want to expand a little bit on the catch?
Well, now that you've gotten everybody so excited about CITs, Michael, I'll put a damper on things, and sorry, it had to fall to someone, right? So Michael, for lots of reasons you mentioned at the outset of your comments, CITs in 403B plans could make a lot of sense for nonprofits. And quite frankly, if there were no catch, it would be a demonstration of your fiduciary duty to at least consider holding CITs as a portion of your portfolio. The catch, however, is a fairly large one. However, it could be removed, at any time. While Secure 2.0 removed the tax qualification rule against 403B plans investing in CITs, as Michael described, it does not impact a currently existing securities law or set of laws that currently prevent CITs from holding those 403B plan assets. So in as simple terms as possible, I'm not an ERISA attorney, nor are we a securities law firm. But in the simplest terms that I understand, to be exempt from certain strict disclosure requirements, these CITs have to exclude assets from certain types of retirement plans, which include 403Bs, sponsored by nonprofits. So, based on that fact, it's unlikely that most CITs will be accepting 403B plan investments until those security laws have been updated. So, long story short, there was a provision that would have allowed CITs to hold those 403B plan assets without triggering registration or disclosure requirements. But that particular provision was dropped from the final version of Secure 2.0. It remains to be seen if or when Congress will enact changes to the securities laws that are impacting sort of the wide availability of CITs to your plans. And so having meaningful access is one thing, having legal access is another. So, if you're dead set on pursuing this route of having CITs in your nonprofit's retirement plan and your 403B, you really should seek, experienced, responsive securities law counsel, or at very least talk to your ERISA counsel about what type of risk you might be taking on by looking at this option. So the downside risk of getting this wrong obviously could be fairly substantial. So, again, I'm not an ERISA attorney, so I'm not going to counsel anybody to wait or to jump in with both feet. But at the end of the day, be very thoughtful. And we may just want to see what comes down the pike here in 2023 from Congress to hopefully remedy the catch.
Well, thank you, David. And I just want to add to the audience, why is this important to, to plan sponsors of 403B plans? Why would we spend, a third of our presentation on this? Well, the audience here attending this webinar really should keep the inclusion of CITs on their radar. Your 401k counterparts have been feverishly adding CITs to their fund lineups based on a couple of things, right? One, to keep costs down, right? And we know that there's a litigation focus in that area, lower investment costs, but even more importantly, lower costs on the investments really benefit your employees, right? They really improve the retirement savings just by having lower costs. So it's one of those things that we're really diligently, focused on, and we want to just give you an overview, but this is going to be very exciting for 403B plans very soon. So, okay. So moving on to the next topic. So let's talk about hardship withdrawals, everyone's favorite topic here. So there has been a change for 403B plans with the Secure Act 2.0. So Michael, can you first briefly describe what's changing for the plans and why it's important to plan sponsors?
Yeah, of course. So Section 115 of the Act is another provision that benefits participants. So until the Secure Act changed, participants were only allowed to take hardship withdrawals based upon their immediate and heavy financial need through their own contributions only, no employer contributions and no growth. So it was really restricting in the amount of money that a participant could take out of their plan if they had an emergency. So effective January 1 of 2024, Section 115 states that 403B plans may also allow hardship withdrawals of non-elective and matching contributions, including earnings on such contributions, as well as earnings attributed to the employee's elective deferral. So basically, now a participant will be able to take withdrawals from all sources of money. The other thing that's really interesting with this act, there's a number of different provisions, but In addition, the Act simplifies the administrations of such hardship withdrawals by allowing 403Bs and actually 401k plan administrators to accept a written declaration from the participant affirming that the request for withdrawal is, one, on account of a hardship of a type deemed to be of an immediate and heavy financial need, and two, not in excess of the amount required to satisfy that need. So this change, effective for plan years moving forward, will allow participants to self-certify that they lack alternative means to reasonably meet their financial hardship. So the flexibility to rely on a participant declaration is good news for plan administrators looking to take advantage of what's called e-certification process offered by a lot of different record keepers. But before you utilize e-certification, I should confirm that the record keeper process of collecting the records that require participants sorry about that. You have to make sure that the record keeper will allow it. That's it.
Yeah, okay. Well, actually, Michael, this is exciting news because I know, in talking with a lot of plan sponsors, they really don't like to be in the middle of these hardship determinations. So taking the plan sponsor out of that decision-making and involvement is a huge benefit to you as a plan sponsor. So hopefully, you're excited about it as well. So David, can you, expand on this and explain why plan sponsors should be thinking about this when considering adopting these new rules?
Sure. So, we've talked about this in the prior 3 webinars. You need to think about everything that you institute in your plan, especially amendments introducing new provisions. You need to think about it very carefully in the context of your employee population, in the context of the existing rules of your plan. Look at your plan holistically, right? Not just in a vacuum, provision by provision. So in considering which provisions to enact in your plan, ensure that you're working with experienced ERISA counsel and great advisors to ensure that what you put in place, number 1, is appropriate for your employee population, as I mentioned before, but 2, it's properly reflected in your plan document. And then those words in your plan document are exactly reflected in the plan's operation. Because when the plan doesn't operate according to the plan document is when you want to hire an ERISA attorney for non-proactive reasons, for a reactive reason, and we want to avoid that. So again, don't consider this option in a vacuum. I'm just going to speak to a couple of different provisions that are also in the Act that have to do with how do employees get what they consider their money if they have an emergency. So there's a separate section in the Act, section 115. We'll just call it withdrawals for certain emergency expenses. It's the way it's worded. And that provision allows a $1,000 distribution with the option for the participant to repay that $1,000 within 3 years, no penalty. Okay, that's new. Another section, section 127, provides the opportunity for plan sponsors to offer their non-highly compensated employees separate savings accounts linked to the 401k or 403b that those savings accounts are then funded by employee contributions up to a $2,500 cap. Okay, so this impacts your employees' ability to take money and then have that money available for an emergency. Both of those provisions I just mentioned. If you enact those provisions in conjunction with the new hardship rules, how is that impacting the overall ease of the administration of the plan? To Michael's point about the disclosures, is your TPA ready and able to do all of the mechanisms in the background, backstage, if you will, to make sure that your plan is operating according to the plan document? So, as an example, Michael mentioned 403B plan sponsors who are looking to implement the new hardship withdrawal section will need to amend their plan document to allow distributions from all the available sources that you're choosing to put in your plan. And even if you're not changing anything at all, you've got to at least change the piece that talks about the elective deferrals only being allowed, because again, now you have, past law had only employee contributions able to be taken out. Now you've got all these different sources from which the money can be drawn, and that needs to change in your plan document So again, taking a holistic look at your plan design.
Thank you, David. And again, there are a lot of provisions in the Act that talk about, increasing retirement savings. So, I would recommend to the plan sponsors in the audience to look at every form of distribution that you have with your plan and kind of evaluate it. How's it working? How's my loan provision working? Or, or do we have excess loans? Are people kind of misusing that? Obviously the hardship, and there's a lot of features here that are available to you as a plan sponsor to help people feel more comfortable accessing their money. But I look at all forms of distributions and kind of make sure they're working really well together. So.
Well, Carmela, you said something in our pre-planning about making sure that the employees have what they need, right? But that you're as a plan sponsor, you're keeping money in the plan, right? And so lots of these are little back doors where money can go out of the plan. So again, I think that's a really great point.
So, well, thank you. So we're moving along to our third topic. We've looked at a couple optional provisions, but we actually have a required provision, and there are a few in the Act. So one, the one we're going to be talking about, it relates to long-term part-time employees in Section 125 of the Act, and it speaks to the eligibility of those employees to participate in a company-sponsored retirement plan. So, Michael, could you just describe briefly the section itself and how it relates back to the stated intent? And then, David, can you close with some commentary on the challenges of this mandated change for plan sponsors?
So, Carmela, you had mentioned the first two provisions we talked about today were optional, and this is the first one that we're talking about that is actually required. The good news is it's not required until 2025, but in order to meet that requirement in 2025, you're going to have to start, if not already, keeping great track records of current employees who are long-time part-time employees. So the intent of Section 125 is to improve coverage by retirement plans for part-time workers. Harkening back to the idea of expanding employee access to retirement plans. So the question here revolves around eligibility and eligibility tracking. And I'm going to ask David to expand a little bit more on that. But what's going to happen is something called dual eligibility. So you as plan sponsors are going to be required to track the amount of time all part-time long-term employees work to make sure that they are potentially available to participate in the plan, except in the case of a collectively bargained plan. So I don't think that's really going to impact most nonprofits, but Section 125 reduces the 3-year rule to 2 years, and it's effective for plans years beginning after 2024, so the beginning of 2025. Section 125 also provides that pre-2021 service is disregarded for vesting purposes. So if this provision extends the long-term part-time coverage rules to 403B plans that are subject to ERISA for employers. So David, can you give us a little bit more background on Section 125?
Sure, and the first comment is really intended for not only nonprofits. I've said this in the former general session when we spoke about this provision. So the first comment will refer globally to people who are offering a retirement plan. Then I'm going to make a comment that has to do specifically with the universal availability rule relative to 403Bs and nonprofits specifically. So first of all, thinking more broadly, this is the provision of the Act that may require the most plan sponsor work or legwork, if you will. For companies without a part-time workforce, obviously this isn't a big deal. But so many companies rely on part-time workers these days. I think a lot of companies could be caught off guard if they don't take a proactive approach. And at HBL, we always talk about taking a proactive approach, not being reactive, but being proactive in your approach to your retirement plan and all your benefit plans for that matter. So the main change here is to the current requirement, as Michael said, that part-time employees must have 3 years where the employee completes 500 hours of service to qualify to participate. That requirement has been changed to 2 years at the same level. So you're taking 3 years of 500 hours of service and you're reducing that look back period to 2 years at 500 hours per year. Now, eligibility still kicks in on that 1 year measurement period for those part-time employees who have 1,000 hours of service in a single year. But you know, look, we're throwing around numbers here. It all points to the importance of plan sponsors keeping detailed and exact records of employee service, including things like hire and separation dates. You know, what if they separated and then they came back? Well, you need to track that, because that's a question you're going to have to talk to your advisor about. It all points to the importance of, you know, again, hire separation dates, total hours worked for every part-time employee. Just making sure that, you know, if you've got service providers who are tracking these things, you're holding their feet to the fire as well. Caught flat-footed, employers could be in a real mess if, you know, God forbid there's an audit and you haven't been keeping good records and you've been not letting people participate that maybe should be participating or have the opportunity to participate. Or maybe worse, because the DOL is required to investigate these, maybe a participant has a complaint, or somebody who thinks they should be a participant has a complaint, and they take that directly to the DOL. That could cause a problem. Right. Now, specific to nonprofits, there is an additional wrinkle, and I've been given all the wrinkles and catches today, I think, because 403B plans are subject to the universal availability rule. The long-term part-time rule may not significantly expand eligibility depending on how your plan is currently operating. So the universal availability rule generally states that all employees of 403B plan sponsors be eligible for elective deferrals with narrow exceptions. So employees who work less than 20 hours a week, for example. So to simplify administration, 403B plans, and many of you on the call probably already know this, commonly just allow everybody to make elective deferrals. Sponsors of 403B plans need to review the terms of your plan as it stands now to determine whether or not an amendment is required to satisfy the long-term part-time rule, and to consider whether to begin doing that careful tracking that I mentioned earlier.
Well, thank you, David. And you know, speaking to our plan sponsors here, we realize that running a retirement plan can come in a long second behind your organization's mission. So unfortunately, offering these plans have become increasingly complex to administer, and frankly, there are a lot of areas where mistakes can be made. And we encourage you to seek out strong partnerships that can help support you on plan administration, compliance, plan design, and best practices, so that you can focus on the important work that you do. So we're going to wrap up. We're not going to have time to talk about the multiple employer plan, but happy to, you know, please, if you have questions, you'll have our contact information and we can talk more about that. But to summarize, some basic steps you need to take: evaluate your employee population, not just today, but in the future. Use these provisions in the Secure Act as a recruitment and retention tool, right? Identify which ones will work best within your organization and really resonate with employees. Obviously, identify elective versus mandatory. That's important, and when these things are effective, and you know, use this as an opportunity. You're going to have to make changes to your plan. There's no doubt about that. But use it, you know, to look at your overall plan design and enhance it. You know, it's actually exciting to evaluate where you are today, where you want to take your plan. And then some of these, there may be some costs involved, so you want to identify any costs. And just, you know, first of all, we hope you found this helpful, and just some basic logistics as we wrap up, because we're pretty much 1 minute over. We will have a quick survey at the end of this webinar. Hopefully you'll help us become better and to better serve you. So hopefully you'll take the the quick survey. We will also have some materials sent out to you, the recording, the handouts, and you'll have all of our contact information. So hopefully, did I miss anything, Michael and David?
No,
Covered it all.
thank you.
So okay, well, thank you very much, and hopefully you found this helpful. We appreciate your attendance.
Keep thinking critically about your retirement plans.
Yes.
Thanks, Carmela. Thanks, Michael.
Thanks.